Felicity is honorary professor at Salford University in the School of Health and Society, where her research focus is on autism and criminal law, female genital mutilation law, and child rights. She is also the Professor of Legal Practice at Deakin University, where she chairs a contemporary international legal challenges program. Topics in this program have included modern slavery, terrorism, war crimes, and climate change law. Today, Felicity will talk to us about why being trauma-informed is an issue for court integrity and what taking a trauma-informed approach might look like for a court, sharing with us her knowledge and insights from her research in this area. So without further ado, I will hand over to Felicity. So thank you so much, Felicity.
Oh, not at all. Look, I'm delighted to be here and thank you so much for asking me to give this presentation today, which is a mixture of the work that I've done as an academic, but also the experiences that I've had in court. So hoping to draw a few stories together as well as hand on some of the research that I've done. I've prepared some slides so that you can have them afterwards because I've put some resources in there. Of research that's brought this presentation together, if you like, is the drawing stakeholders who use the court system. So what I tried to do was, what I'm doing was this between, but I thought you to see the sources that I use to tell a bit of a story. So I've done a lot of really progressive research around juries and jury deliberation. And she, along with other experts, were invited to run a project in the courts of Trinidad and Tobago, where there were issues in any other research project involving the courts, in my opinion. Really groundbreaking stuff and the sort of access that, in my opinion, would be really useful in any court. Let's have a look at ourselves. We're going. And obviously what I've given you there is one of the sources of the report that comes from that, and I'll talk a bit more about it in a moment. There's trauma seriously. So number two I've given you there is some academic research in the International Journal of Evidence and Proof around the justice process, largely for victims, but also for other stakeholders, looking at how traumatic it can be from a number of perspectives and thinking about how we might want to develop our court system. That's not to say that we throw the adversarial system out completely, but recognizing that the experience can be traumatic for a range of stakeholders. Work has gone on in the American Bar Association, attorney-client relationship, particularly those lawyers who are working in child law and practice. So for those of you who are sitting in courts where children are accused or children are witnesses, it's quite a useful source to have a look at how the American Bar Association was looking at lawyers' practice in those types of cases and the impact of trauma on the way in which the attorney-client relationship works. There's also a report submitted to the House of Delegates in America in 2018 about being trauma-informed. Rosalind Carnes, also from Deakin University at the time, she's published the case for trauma-informed lawyers. What we're talking about today, of course, is trauma-informed courts, but that involves all stakeholders, or at least all the professionals working in the system, understanding what being trauma-informed means. And then, of course, thinking about secondary stress for lawyers and judges working in courts. There's some interesting reports from the International Bar Association on bullying and harassment in the legal profession. Most of those should have a bit of an idea. You've worked with vulnerable people for a very long time. You'll have made some changes about the questioning of vulnerable people, but this is about considering whether these piecemeal changes are really only piecemeal, and we have to have a much more holistic approach to the way in which a court works. And what I included in the research were some sources that may not be familiar with you. So some of the work that I do in Victoria relates to trafficked persons who commit crime. Now, in England and Wales, there's a complete defence for trafficked persons who commit crime for some offences. So mostly there's policy around not prosecuting trafficked persons who commit crime. Sometimes when they are prosecuted, which is relatively rare, there is also a complete defence. And an awful lot of work has been done to work out how to identify if your client is a trafficked person, and how to communicate with a client who's a trafficked person, and of course how to engage with a trafficked person sufficiently to refer them to what's called the national referral mechanism, where they can be formally assessed and where their traffic status can be acknowledged by the equivalent of the OPP. So it's a really interesting mechanism that doesn't exist in Victoria. I've got a grant from the Legal Services Board of Victoria to have a look into human trafficking in the criminal justice system in Victoria, which you may have seen on their website. So it's something I bang on about quite a lot, but it's also something that came into this research, because if you think about it, if you look across your courtroom as magistrates, do you know, particularly if you've got, let's say, a drug case before you, do you know if you're dealing with a trafficked person? What's the mechanism for you to find out? What can you do about that? Do you ever ask, has anybody thought about this, whether or not this person is trafficked? That's what we come up against with judges in England and Wales. That this duty is developed for judges to actually say, has this been done? Has there been an assessment? Have they been referred? And there is a referral mechanism in Australia. Perhaps, unfortunately, it's run by the AFP, but there is a referral mechanism. There is a policy. There's a national action plan. And so here on this slide, some sources about particular types of people that might come before the court. So that might well be traumatized by their experiences, but also by their experience of coming to court. Because, of course, you can see how they might not be criminally responsible, but they're under pressure from both their traffickers and the state system. And that pressure tends to mean that they keep quiet, and therefore we're prosecuting trafficked persons. So some really interesting resources around from the UNODC, the Anti-Human Trafficking Manual, the Slavery and Survivor Care Standards that's been endorsed by the UK Independent Anti-Slavery Commission, and the Trauma-Informed Code of Conduct for all professionals working with survivors of trafficking and slavery. And you can start to see from what I'm saying, I'd cut off those last words, and what we really ought to have is a trauma-informed code of conduct for all professionals, that we can start having measurable actions that can take place in court systems. Real issues around trauma for women, of course, and there's a little test that I ran when I gave a similar lecture to the judges in Canberra at their judicial training college. And I asked, when I was giving a presentation about women in the criminal justice system, how many of you have read the Bangkok Rules? Now, Victorians are doing some really good work around women in prison and recognising women are vulnerable in prison. But I'm not going to ask you to put your hands up. I did ask them to put their hands up, and I did say, come on, don't be shy. And I think out of a room of maybe 80 judges, maybe 2 of them have read the Bangkok Rules. And I think what's really interesting is a lot of what's happening or being talked about and discussed in Victoria is already in the Bangkok Rules and has been there since 2010. So I think worth informing yourselves as to what the international guidance is there, and reflected very well, in my opinion, in the inquiry into Victoria's criminal justice system. You'll all know about that. You'll all have read the section on trauma-informed practice. It's a bit short in the report, but it's in there. I think it's page 770, but I can check that as we go along. I think there's some really interesting things to note in that inquiry. I didn't use that in this research, but I've developed this research in a way that I'll come back to in a moment. But they talk a lot about victim perpetrators. I think one of the really interesting things about that report is I think there was an expectation, and I remember hearing people saying, oh, it's just the victims lobby. There was an expectation that this would be a very one-sided, unbalanced report. And I think there's some really good work been done in there around victim perpetrators. And what I'm delighted that the report picked up on was one of my submissions on taking a health law and education approach to criminal justice. So what I've given you in the last source there, submissions 75, 86 and 145 were the 3 submissions that I made to that inquiry, some of which are quoted in the report and some are not. They didn't quite touch the human trafficking aspects, but did talk about victim perpetrators. They adopted a lot of what we said on health law and education being the way forward. They said a lot about bail. They didn't adopt the neat point that I like to make, which is international law talks about the least restrictive means. And so when you're sitting on a bail application, you think you might have a traumatized person and you make the right inquiries about that person, and you understand that they might have trauma issues. If you do that, then it might make a difference to your bail decisions. And if you think about that test in international law, am I using the least restrictive means? I think that's a good way of looking at your interpretation of the Bail Act. There are, of course, some black letter lawyers who wouldn't agree with me, but I think it's really important to ask yourself that question. Am I using least restrictive means? So those are some sources that allow us to think differently about what we do, about being proactive about trauma, to recognise that trauma may occur in many different respects. I came to this research with some personal experiences that I think are worth sharing in this respect. So first of all, I've spent a long time examining and cross-examining children and other vulnerable people. We've made some really interesting inroads into that in Victoria, how to question and cross-question vulnerable people. I worked for a long time for the Advocates Gateway, which developed toolkits for advocacy with vulnerable people. And I'll come to some tools later on that I've used for that type of advocacy. And it's really a different way of questioning people that, in my opinion, does seem to give more, I don't want to say more accurate, but it does help to understand what the person is trying to say, particularly if they're a child or they've got cognitive disabilities or mental health problems, different difficulties with time, and so forth. So developing toolkits for how to question people, I think, has been really useful. Obviously, I have to persuade judges and juries, and you have to start thinking about the issues that those people might have. We know nothing about the jurors that we sit with, and we might make jokes about the judges that we're in front of, but you might well have a judge who has cognitive issues or some sort of autism or autism spectrum disorder. And we have to think of those as ways in which we have to communicate with people who function in diverse ways. Obviously, during the course of my career, I've had to deal with discrimination and a lack of diversity. I think in my last 15 murder trials, I've been the only female silk except in one of them, and the only woman in 11 of them. So obviously, I have concerns that women leave my profession, and it's brilliant to see so many women on the bench in Victoria, but obviously you're working in an environment where you still have comments about what you wear, difficulties somehow with your name, a culture that isn't necessarily very feminine, and of course low numbers of women at certain levels, which is a real concern. And I think it's really important in the magistrates' court, where you might have a lot of women working in these traumatic cases, and you want them to carry on, and they might be doing magistrates' court cases at the beginning of their career, and you want them to carry on 28 years later to be where I am. So I'd always push being trauma informed about particularly the young lawyers that you might have in front of you. We have to deal with viewing violent, abusive and other shocking material. We don't really have a system for helping us to deal with that. We have to, as defence counsel, as I am now, no one's ever sent me a prosecution brief since I took silk, but I did prosecute and defend about 50-50 as a junior. So I've dealt with lots and lots of clients at every level problem with disabilities, mental health issues, and other vulnerabilities, including long-term alcoholism and addiction, as well as being victims of sexual abuse and human trafficking. So what I try and do is look at law reform and education in court. I think there's real space for using a court to educate the professionals within it and the public about being trauma informed. So what do we mean by court integrity? And how do we link being trauma informed with the integrity of the court to motivate all of you to want to be trustworthy? You think you are, but are you really? There's the question. And would being trauma informed, and obviously trauma informed, improve trust? So the preceding Fairley report, the Trinidad and Tobago report, has a foreword in which Justice Peter Amadar says this: acting with integrity demands consistent behaviour at all times and in all circumstances, requires transparency and accountability, and contributes to a felt sense of social justice. Institutions and persons, especially leaders who are experienced and perceived as consistently acting in integrity, are considered trustworthy, reliable, and morally authoritative. They are consequently vested with credibility, legitimacy, and found to be deserving of respect. Acting out of integrity has the opposite consequences. And a lot of what I speak about in this context, you think, oh, I already know that. Yes, I know I'm trustworthy. We have systems to be fair. But if you start to ask yourself, you sometimes come up with different answers. And the integrity of the court can be derived often from its approach to procedural fairness. So it's not about individuals necessarily, but an individual might undo all the good work that a particular court centre is doing. So the preceding Fairley report identified academic research about what does procedural fairness mean. And these 4 landmarks, I think, are something that you should remember every day. So they were developed in academic research as long ago as 2008. Voice, neutrality, respectful treatment, trustworthy authorities. And you can think of many times when people's voices have been shut down, commonly because you're so busy, and there's a problem in itself. Actually giving time to cases might be necessary. One vulnerable witness that I had as a 13-year-old girl who was raped by her stepfather, and she had cognitive impairment. It took her 5 days to give evidence. And the immediate reaction of everybody is, that's terrible. How could a victim be in the witness box for 5 days? But actually, that's what she could manage. We did half a day at a time, no more than 30 minutes at a time. She was exhausted at the end of half a day, and we let her go home, have the afternoon off, and come back again. But it was really hard to get the judge to agree, and it should have been really easy. So I think that's just a good example of voice, where someone's voice might be cut off by the pressure that we're all under to do cases quickly and efficiently. Neutrality, not just being unbiased, but being transparent about how decisions are made, so that the way in which you deliver judgments are not formulaic, and that you not just giving over your reasoning, but a lot of why am I doing this? It can be really interesting in a bail application or in sentencing. Why am I doing this? And I did a really interesting case in Victoria of a woman who put her baby's face in the bath, and she had mental health problems. She'd gone to commit suicide earlier that day, didn't, went home, thought about it again, put her baby's face in the bath. Obviously pulled him out, dried him off. He wasn't harmed at all, and then slept on it and phoned the child services the next day, with whom she'd already had some supervision. She'd recently been returned to look after her children. She said, oh, look, guess what I've done? You know, can I have some help? And instead they sent the police around, and she was prosecuted, originally charged with attempted murder. In the end, we negotiated an alternative. And the judge in Victoria was brilliant. She really understood all the research. We produced the academic articles about the vulnerability of women who harm their children. and she gave a non-conviction outcome with a community penalty. And again, it took an awful lot of work, but really knowledgeable judge that took the time to understand it. Along the way, we had some terrible experiences. My client was bailed after about 8 months in prison on remand to her sister's address by a judge in the Supreme Court, and the police and child services turned up at the sister's address and said, if you let her in, we'll take your children away as well. All pretty shocking and certainly not trauma informed, in my opinion. So respectful treatment, trustworthy authorities, you'll have heard those labels before, but it's about thinking about these 4 landmarks working together. And I think what's crucial from this research is what they say at the end, and I've highlighted it for you. This is crucial, as issues of compliance and perceptions of legitimacy are pragmatically more remarkable in relation to losing parties. So what these researchers found was, if people lost, they respected the decision because it had been transparent, trustworthy, respectful, engaged, and enabled them to engage voice and neutrality and appeared to be unbiased decision makers. So there was this real trust in the system amongst people who lost, which was really interesting from that research. How do you get the people who lose to trust the court? I'm not going to read this slide to you, obviously. We'll be here all night or all morning. But again, back to the Trinidad and Tobago research on the subject of integrity, fairness was also linked with obedience. So in addition to the 4 landmarks that I've shown you, they also looked at accountability, availability of amenities, access to information, inclusivity and understanding. And in a trauma-informed way, that might have to be information, for example, not just written down, not just oral, but visual, for people who process information in different ways. It's not about sticking a label on the door. You might have to have many ways in which information is given out to people using the court. But what that research found was, actually, if you have an all-of-court approach, developing trauma-informed processes that cater for everybody, that's witnesses, suspects, defendants, investigators, lawyers, judges, jurors, court staff. If we look at it in that way, what the research has found is that type of fairness is linked with obedience. You get people being better behaved in court, or less likely to be objectionable in court. So linking integrity with procedural fairness with trauma can drive that all-of-court approach and bring with it this modern knowledge that we know about people's, we'll call it vulnerability, people's traumas, and to educate not just ourselves, but the people using the court system, and of course the wider public who can see how the court system's working in a trauma-informed way. I think that becomes really important when we have a system that sometimes you get a knee-jerk reaction because of one big case that horrifies the public. And somehow we've got to make this trauma-informed approach of court so legitimate that the public would recognise, well, that's an extreme case, but all the other cases are being dealt with really well. That we're recognising people's mental health problems or addictions or generational trauma, and doing it in a way that's similar to trauma-informed care. So, of course, we know that trauma-informed care is well developed in the health sector. If we take a health law and education approach to court systems, then particularly in criminal justice, we can sort of use some of these developments in care, not to create carers out of ourselves. It's a different process, of course. So use some of those processes to work out how we can assist people to cope with the range of adversities that can come from being in the criminal justice system. And that includes risks to lawyers of vicarious trauma and ways in which people can be triggered to react badly, for example, or to feel traumatized by the very process that they're going through. And that becomes important in encouraging people to come to court as victims, or encouraging people to engage as victim perpetrators so that you can understand their story and so forth. I hope I'm doing all right for time. I tend to talk for England, and I'll just have a check how long I'm going half an hour. Okay, I'll keep going. So integrity, procedural fairness and trauma. We've got a bit of an understanding about those three things. Again, I'm going to repeat, we all think we know, but it's really worth seeing how the research has developed in this way to bring them all together. My research then looked at trauma-informed courts, as I say, as an issue for integrity. So looking back at what Rosalind Carnes put in her research, she said, as a powerful institution in society, law regularly encounters and deals with people both as victims and offenders whose lives have been shaped and harmed by traumatic events. And I'll just stop there to say I gave a presentation last week, also at a funny hour of the morning, in the Northern Territory in Alice Springs, in which they were trying to work out how to improve advocacy with children as after the report into the detention of children. So there's work being done across Australia on how to improve the way in which courts work. So probably worth speaking to your colleagues in the Northern Territory as well on these issues. But she focused on practical ways in which to work effectively and sustainably with disadvantaged clients whose lives, circumstances and legal matters were often complex and chaotic. So she suggested training, reflective practice, working effectively with clients, as well as addressing your own self-care. Remember, this was about trauma-informed lawyering. So you have to take that extra step. What do we have to do to address ourselves, but also those people that who are the stakeholders in our court system? I like to mention reflective practice a lot because a judge in Victoria once said to me, I don't want people passing their law degrees based on an essay on reflective practice. And I said, well, I think that's exactly what they should be doing. It may not be one of the priestly 11, but I absolutely believe that that's what students should be doing. So we had quite a row about that. And I think it was really unfortunate that not a magistrate, a judge was taking that approach as though we shouldn't even be teaching reflective practice to our students. I think future lawyers will be far more trauma informed than we are. And I think my students are really good at reflective practice, and we teach it in our legal clinics at Deakin. So I've got some top tips for you. And of course, the first one is that reflective practice, not only being trauma informed. Go away and read all the sources. Disagree with me if you like, but I think it will change some of your practices. It's certainly changed mine. I try really hard to be trauma informed. Obviously, I have to go into battle every day. In the sorts of cases I do, which are mostly prosecuted and defended by middle-aged men, I always say it's middle-aged men going to war when they haven't got a war to go to. So I'm often in that really high octane adversarial battling mode, which I actually quite enjoy, which is so unhealthy. So I often not only think I've got to be trauma informed and remember all that I've learned, but also reflect on it at the end of the day. Have I sort of lost it along the way, or have I not stuck to the principles that I've learned? Have I practiced in the way that is best for my client, or the most appropriate approach with the judge? So reflective practice is not about self-harming. Oh, did I have a bad day? It's, how am I going? What do I need to adjust for this particular case? And not in a sort of ad hoc way. Oh, you have to think about how good you are, but actually really deeply diving into reflecting on how you're working within the system. I want to give you time for questions, so we'll just canter through these. What I call special measures, but you've got a few of these, obviously. Adjustments for vulnerable people who come to court. We've got an intermediary system now in Victoria for victims, which I think is really useful. And I was part of the Advocates Gateway that developed those. They were pioneered by Penny Cooper, who runs the Advocates Gateway. The idea of having people who can help you communicate with vulnerable people in the system, I just think is a bit of a no-brainer. And we know so many barristers, for example, who can't ask a simple question. Training them to ask a simple question, really good idea. I learned to speak simply teaching children to ride horses. No one ever trained me when I was starting out as a barrister. The intermediary system's really helpful. In a recent murder trial that I did, the main eyewitness to what had happened was a 12-year-old boy sitting on a container watching down a street, and he'd seen the car pull up, stop, people get out, person in the street was stabbed, and then the car drive off. And my client was the driver. And it was really important piece of cross-examination to show that whether or not the car was pursuing the person or had slowed down, whether the car went straight on or parked around the corner. And the police had done a reconstruction in which the car had gone straight on. My client's case was that he'd gone round the corner. So there were some really important questions to ask of this child to make sure that he could understand my questions, and then maybe my client was right. And he was. In fact, my client was acquitted. In the end, the prosecution suggested he was a drop-off driver, and you couldn't say whether he was drop-off for drugs or drop-off for violence. So he was found not guilty. But the child, how do you ask a child to differentiate between a police reconstruction and the events on the day and put your client's case? It was really complicated. And some simple things, I'm not going to tell you the whole story, but number one was, I spoke to the intermediary in advance and said, this is what I want to ask about the car. And did the car go this way, car go that way, and the reconstruction with the car. Perfectly normal language, very simple. And she said, I wouldn't use the word car, use the word golf, because it'll get muddled up, whether it's the car in the reconstruction or the car in the on the day. So describe the car itself. You saw a Golf, the black Golf and the blue car. So we could differentiate between the reconstruction and what I was putting about the day itself. And the second thing she said, well, what you really need is some toy cars. So although he's 12 and he's quite sensible, the toy cars will help. If you've got a map, you can put the toy car on. He can show which way the toy car went on it was by live link on the video. So my junior ran out to the market and bought some toy cars. And by the time I cross-examined this boy, I handed them out, gave them to everyone. No one used them except me. By the time I'd finished with these cars, and I said, can you stop it where the car stopped and draw around it so we can see where the car was? What was the angle of the car? And by the end of it, my client was a drop-off driver, not a getaway driver. It changed the whole nature of the case, and I think significantly contributed to his acquittal, but also enabled the child to give evidence. I was able to say, look, I know you're not a baby and these cars are a bit silly, but I think they'll help me to understand your evidence. And it worked really nicely. For some people in your courts, I think it's important, perhaps they don't have their hearing at all until they've had a health assessment. In the Northern Territory, when I lived there for 5 years, ever so many of the Aboriginal children that were coming to court had hearing difficulties. They had what we used to call glue ear. I'm not sure they even knew what was going on or could necessarily hear. And I went to one shocking hearing where the magistrate was sort of shouting about the 3 R's, reading, writing and arithmetic. So it was all very odd. Support structures for families, making sure that waiting times are not draconian, saying you've got to be here on time. People might need feedback about timings. They might need support about what time to turn up. They might need to cope with waiting times or not waiting and demands to be in attendance. Family support for witnesses and suspects or accused persons. The peace system for planning and asking questions. All of that's in the research. Educating ourselves about the effects of drink, drugs, people who might have health issues, people who might be hungry. I think it's a real shame because often I think people should be fed at court, and there are people who can't afford to use a machine to be fed. This idea of trafficking referrals that I've talked about, professional care, recognizing when someone might be burned out, emotional or overloaded, even someone who's in front of you in court. And particularly women, when you look across the court, if you remember nothing else from my presentation, I hope you remember the trafficking stuff, but if you remember nothing else, when you look across a court and you see a woman in the dock, always remember that that's exceptional. It's a tiny proportion of people in the criminal justice system. The moment you've got a woman in the dock, you've got an exceptional case. And that, you know, it might be a mother, it might be an Indigenous woman who are the category of increase in sentencing. They might have very specific needs, and you need to give all of these people dignity and respect, and yourself. So it does require change to have trauma-informed courts. The preceding Fairley report concluded that for a system to be trustworthy, reliable and morally authoritative, and then for justice to be done and to be seen to be done, it's not trite to suggest it has to be done with transparency, accountability, and by contributing to, I like this a lot, serving the community, this phrase, the felt sense of social justice to the community it serves. So I love that phrase, felt sense of social justice to the community it served. Here's some quotes from me. I'm not going to read them out, but it really brings together what I've been saying about bringing together integrity with being trauma-informed, having that all of court approach, taking all of these things seriously, does result in changing the way that we do criminal justice. Thank you. So I can talk through some more of that. What I've done is give you the sources at the end of the articles that I've published. Some of you might not be able to get access to the New Law Journal, which is the part 1 and part 2 at the bottom there. But what I did do was write a version of it for Legal Wise, which is in the link on that last slide. So that's some of what I want to say. I hope it was useful.
Felicity, thank you so much for attending at 4 a.m. UK time today. And thank you today, and to Anne for organising.
Thank you for having me.
Thank you.
Take care.
Goodbye, everyone.
Carry on the good work.